So over the next hour, we're going to go more in depth on the legal AI specific tools. Up till now, we covered general purpose AI, best prompting tips for using ChatGPT, Claude, Gemini, DeepSeek. So we're now going to shift to those legal AI specific tools. We just got some insight into the e-discovery tools in practice, like relativity. There are other ones. There are other ones called Disco, and there's also Lexby. Those are all e-discovery platforms. But as you can see, I don't know what's going on here. 1 second. Okay, hopefully that works. So as you can see, document review used to be this huge manual process one by one, but now is being automated by AI, being able to flag relevant documents, being able to flag potential hot documents. So we already saw e-discovery, some of the tools in action there. That's something you are going to encounter, most likely whether you're in government, whether you're at a law firm of any size. Reviewing documents and doing e-discovery is a pretty innate process, especially in the litigation side. So shifting over to talk about using AI in legal practice, I like to break it up into two different things. One, it's actually learning about how AI is used. What are the tools, seeing them in action, what are the best practices? And then two, understanding what our ethical obligations are when we're actually using these tools. So this is what we're going to cover over the next 2 hours. But I'm first going to start with an overview of some of the general trends and understandings of AI use in legal practice. Starting with one, AI tools are a good first draft right now. It's not going to get you over the finish line to a finished product. Mentioned this yesterday. Emily also talked about this, the partner from Jones Day yesterday, how AI is not good enough to give you that final product. It's good at brainstorming, good at idea generation, but not great at drafting final products. It is good at e-discovery as well as contract review. Two, still very prone to hallucinations and variation. Attorney oversight is totally needed. This goes hand in hand with number one. We've even seen the AI tools themselves will tell you this is AI generated, double check it for accuracy. Very prone to hallucinations. There's a study out of Stanford from it's kind of dated now, May 2024, saying that Lexis AI hallucinated 17% of the time, and then Westlaw hallucinated 34% of the time. So imagine using Westlaw in practice and relying on it, and 1/3 of the time, it's going to be wrong. So hallucination rates are still very high. And there's the example I mentioned. The above response is AI generated. This is right from Westlaw's co-counsel. May contain errors. It should be verified for accuracy. Not replacing lawyers for now. There's a general industry understanding that now lawyers are not going to be replaced, but I do personally think that'll change maybe the next 5 to 10 years. I think over time, you'll see that AI tools are slowly cutting away at lower level tasks such as document review. 10,000 documents could take weeks to do. That's attorney hours. The fact that it's now automated by AI, that is taking away time from lawyer hours. So I think as long as there's more work coming in, lawyers will not be replaced, but slowly different functions of practicing law are being replaced by artificial intelligence. The question is how quickly will that happen, and will there be new things for lawyers to do, and will the practice of law fundamentally change to a new model? AI has historically been utilized in e-discovery and contract review. That AI-powered e-discovery tool from Relativity, that's newer, like doing that predictive tagging, having an explanation be written, that's being generated by generative AI. But AI has been used in e-discovery since 2015. It's called TAR, Technology Assisted Research. So even in the past, you were able to take a sample of documents, be able to identify certain keywords and patterns in a small sample size, and then be able to extrapolate that to the broader document production to identify things that are potentially relevant. So AI, in the broad definition of AI, has been around in e-discovery for much longer, and that's led a lot of law firms to trust it more because it's been pretty reliable. You're able to benchmark it, meaning you're able to see the accuracy rates and see them improve over time. So there's a lot more acceptance of AI use in document review and e-discovery, as well as contract review, because contracts are typically very formulaic. So it's the same stuff, same provisions over and over again. So contract review, AI tools could easily look and see, is this section missing that's typically there? So it's more stable in its outputs, it's more well accepted compared to generative AI tools, which like we know, could be randomized, could hallucinate. So there's acceptance in these two areas much more broadly than the use of it for contract drafting and legal research. And then legal professionals, we have an obligation to understand the tools that we're actually using. at least 40 states require technological competence. Clients increasingly expecting law firms to use AI for cost savings and faster results. As we know, companies are integrating AI, and companies like to cut costs. So if they're hiring outside counsel, there's going to be the expectation their outside counsel is also being more efficient because they don't want to pay bills for attorneys to do things manually if it could be done a lot faster and a lot cheaper using AI. So I had a partner in a last class I talked to from Kirkland Ellis. He said his clients are still 50-50. 50% say, yes, use AI. We want cost savings. We want you to be more efficient. The other 50 say, don't use AI because they're scared about potential data breaches. There was a case involving Samsung back in 2023 where I believe it was a developer putting company code into ChatGPT and it was regurgitated out. So there are still clients out there in big companies that don't want their lawyers using AI out of fear of data leakage and potential bad publicity coming out of that. Discussions of a transition away from the billable hour to a flat fee model. Anyone who understands some degree of law firm economics, can you explain the tension between AI use and economic models that businesses currently operate on? Anyone have an opinion why law firms may economically be disincentivized to use AI? Yeah, so some of you may or may not know, if you go work at a law firm, the overwhelming majority bill based on the hour. So the more hours you take to do work, the more the law firm, in theory, bills, and that's more revenue for the law firm and law firm businesses. So if you were to come in and say, as a vendor, hey, I got this AI tool, it's going to cut your contract drafting in half, we're going to save you 10 hours a week, you're the owner of the law firm, how's that sound to you? Maybe not great. Now you're billing 10 less hours unless you could make that up doing other work or having more clients. So there's this tension between AI and the billable hour where will we transition away from billing hourly to flat fee basis, where you have a client come in the door, they have an issue, rather than billing them per hour, you would just say, pay us $10K and we'll get this contract written, we'll do revisions, we'll negotiate, et cetera. So there's a lot of talk about this. There's always been a lot of talk about the shift from the billable hour, but I don't see it changing anytime soon. I did a survey of tech CEOs for an article last week. Virtually everybody said they're not going to see a shift away from the billable hour. But they're also economically incentivized to go along with that because they're the ones selling the tools to these law firms too. So take that with a grain of salt. And then firms have concerns over AI misuse and lack of training. There was a survey out in law.com saying that this was one of the biggest concerns. This, of course, is juxtaposed the wide filing of AI hallucinated cases where law firms, you don't want to be that law firm that as an associate use Gen AI tools and then file a hallucinated case in court. Looks terrible for the law firm. And my final note before jumping in, yeah, question?
Is there any data that shows any additional costs that law firms have incurred from having to rectify issues with AI like hallucinations, like refiling fees or things like that?
Yeah, it's a good question. I don't know specific aggregate stats, but all these cases they usually make the headlines. So there's the one from November 2024, just a couple months ago in Texas. There was this one in Wyoming last week where the judge's decision is still pending on what sanctions to give, what fines. But a lot of these cases have resulted in fines for the attorney specifically. And then the guy in Texas was mandated to take a CLE on AI. So I don't think it's huge financial hits, but like the PR side and being in the headlines and getting sanctioned, that's probably worse or equally as bad. So no aggregate stats, but all these cases are publicly available, so you kind of check out on a case-by-case basis how these judges are looking at these cases. So one quick note before jumping into the tools and more substantive aspects of AI in legal practice. A note, and this logically just makes sense, AI chatbots could give you a work product, but you as a lawyer, how are you supposed to know if it's good if you don't know that area of law? Because you're just going to get a bunch of stuff, and if you were to search right now, explain quantum computing, write a memo on quantum computing, you'll get a memo, but if you know nothing about quantum computing, how are you supposed to know if it's good or not? So that also translates to law, where if you're an attorney, a first-year associate, writing a memo, and you use generative AI to write it, sure, it might make sense in terms of structure and grammar, but substance-wise, how are you going to know if it's good if you don't fully understand that area of law? And that's an important perspective to have, and that's why for the time being, lawyers are safe because ultimately AI could give you an output, but you need to have the skill set and substantive knowledge to evaluate if that output is quality or not. So that's an important mindset to have when you're using these tools. So this is a recap before we jump in. This is kind of the overarching. We talk about the ways AI is being used in legal practice. We just heard about and saw the process for how it's being used to expedite e-discovery and document review. We talked about predictive decision-making and analytics, how it's been used to predict potential motion outcomes, case outcomes in different matters, as well as predicting whether documents would be potentially relevant. We talked about how it's being used in research. So legal research and analysis, we have CoCounsel, which you all used and did exercises in preparation for today, so you should be familiar. Lexis as well. You did exercise from yesterday using Lexis, so you should now have experience actually using these AI-powered tools for legal research and analysis. Any of legal writing and contract drafting, as well as contract review. I'm going to show you an example of that live in action to show you how AI is also changing transactional law as well. As a preface to these tools, I'll say a common misconception is that they're building their own LLMs. And for the large majority, that's not what they're doing. They're taking what we call an API, application programming interface, which is basically just taking the core technology and building upon it. So they're using APIs, these companies like Harvey, Lexis, Westlaw, Disco, Relativity, they're all taking the API from OpenAI, using that ChatGPT core technology, or they're using Gemini's core technology or Claude. Some people use DeepSeek, a little questionable. But they're using these core technologies and then building their AI-powered legal tools on top of them. And what they're doing is they're fine-tuning them. And as we learned yesterday, fine-tuning is when you're adding in extra data from a specific domain. So for legal companies, they're adding in, let's take contract drafting. You have contract drafting tools that plug into a Word document and allow you to use it basically as an assistant to analyze your contract. That's Spellbook. What they did was they took the core API from OpenAI, that core foundational chat back and forth. They fine-tune it using hundreds of thousands of examples of ideal contract law, just literally examples of contracts and provisions, fine-tune the model. So now that data set has a lot of great contracts in it and the ideal precedents. Now when you chat with that bot, it's able to give you great responses tailored to the practice of law and contract law because it was augmented with that extra data specific to that domain area. So that's what these companies are doing. They're not new large language models. They're taking the existing ones, fine-tuning them, improving them for specific domain use cases in the practice of law. And here's a little behind-the-scenes action of what goes on with legal AI tools and why earlier I said prompting practices for general-purpose AI, totally different than legal AI. Because what these developers are doing behind the scenes on these legal AI tools is this. They're presetting messages behind the scenes that you do not see as a user. And these are called system messages. And this is an example of actual code snippet of what would go on. So this would be a system message, and pre-prompted in the background, the developers would already put into your chat conversation with CoCounsel or Lexis Protege, and already say, you are a legal expert providing professional advice on contract law. And then this is what me as a user puts in. I don't even see that happening. They already pre-prompt it because they know you're a lawyer already. You're using their tool for legal purposes. So it helps save you time, but that's why you don't actually have to put the prompts in yourself. You just go right to the question. And this is what it actually looks like. This is what you see. So you can see my inquiry. I ask here, what is consideration? And it just gives me the answer, what is consideration in contract law? This is hypothetical. I'm not on the back end at CoCounsel, but this is hypothetically what you would see going on in the back end, preset in the code that is not obvious to you. They would already preset, you are a legal expert providing professional advice on contract law. This has to give you some behind the scenes information, but also relevant to your use of prompts and non-use of prompts in these contexts. So learning about AI tools, there are hundreds, possibly thousands of AI-powered tools out there. A lot of them have existed well before the boom of generative AI, and now everyone's just integrating AI because it helps you fundraise money, among other things. So this is a list, just a small list of some of the companies out there. You have AI tools for law firm management, for billing, for IP management, for B2C legal tech. There's a lot out there, and we're just going to cover a couple of them and the ones you're most likely going to encounter in legal practice. So starting with e-discovery, we already know about Disco, we know about relativity, I've mentioned those. Legal research, you're going to interact with Westlaw, of course. Most law firms will give you access to Westlaw. Lexis plus AI, now launched as Protege. That's another one you're going to interact with. So when you use it in class here, it's actually very relevant to legal practice. You're going to continue using these tools in practice. Paxton and Harvey, I assigned you guys Paxton on Monday. You got to try it out free. You might use it, might not. They're targeted to smaller law firms and mid-size. So if you're practicing in that area, you may actually use Paxton instead of the more expensive tools like Westlaw or Lexis. And then Harvey's a newer one. They just raised like another Series D, $300 million. So they're going to be around a long time. They're used by 30% of the top 100 law firms in the country. And this is another workflow automation, document review. You could drop in a bunch of documents for a deal, and it'll automatically extract whatever data you ask for. So it's a workflow management. You could also use it for niche research, like ERISA. So that is another quasi-legal research, quasi-workforce workflow for law firms. Here's doc analysis, drafting, and workflow. Again, a lot of crossover between these. A lot of these platforms are becoming one go-to platform for everything, not just legal research, but now drafting. Co-counsel has basically everything now between drafting, legal research, and all that. And then contract analysis and drafting specifically for contracts is Spellbook and DraftWise, and I'm going to show you Spellbook. So without further ado, rather than talking about these things, we're now going to go into action and actually see some of these tools at play. So first, we're going to start with AI and legal research. I'm going to show you Westlaw, Co-Counsel, as well as Protege from Lexis. I'm not going to show you Paxton because you guys already did an exercise on that for class yesterday. So Co-Counsel, we're going to jump right into it. All right. So you could access Co-Counsel just by going to Westlaw Precision. And you go up here on the top. This is how you access Co-Counsel. You click it again. And you can see here on the screen, you'll have all your recent chats here on the side. You'll be able to manage your databases and favorites. You could favorite conversations. Databases where you could upload documents. So if you're doing a legal research assignment, pending approval from your professors, you could find all the relevant case law, drop in all the cases as PDFs, and actually have a chat with those documents specifically, where it close off access to anything else. So you could ask questions, oh, which one of these cases had XYZ, factoid or something like that, and it'd be able to find the case for you. So I created a database of personal jurisdiction research, which I'll use for exemplative purposes. But we're going to go back to the main screen here. This is what you see when you go into Co-Counsel. So we're going to start with research, and you'll see all the capabilities. You could research, you could review documents, you could summarize documents, draft, and you have more down here. You can prepare for a deposition as well. So we're going to start with AI-assisted research. And when you open it up, you can see here you could have an option. You could search AI-assisted research, which will take you to search through Thomson Reuters' full database as if you're actually searching in Westlaw Precision. It'll tap into that information. Or alternatively, we could go just into one of our databases and have that conversation with chat with documents function. So we'll start with AI-assisted research here. And it auto writes this. And again, you're going to go right into giving your inquiry. You're not going to prompt it, act as, you are this. You just go right into doing it. So we're going to do, in Ohio, what is the rule for personal jurisdiction over an out-of-state defendant? And if you guys want, you could follow along as well. Totally optional. I know some people have or do not have their laptops. So when you put an inquiry, kind of annoying, but every time you put an inquiry, you have to now manually select which one you want to go to. And here are the differences. AI-assisted research will take you to primary sources. It'll take you to legal cases, statutes, laws, regulations, whereas if you click on search and summarize practical law, that's going to take you through secondary sources, all those practical law insights. So this is an important button to figure out which one you want. I'd say for the most part, you'd probably use the AI-assisted research if you're doing research on memos, although your professors may like if you start with secondary sources. So let's go with the primary sources to start. And at the same time, we're going to do a simultaneous search in the old-fashioned way. So we're going to go to Westlaw Precision. I'm just going to type this in. Best practice would be selecting jurisdiction, but we're just going to do broad-based because that's what we're doing in the other one, and we'll see which one's better. That was pretty quick. We're still loading over here. But the old-fashioned way, we get these. You can see here the determination whether an Ohio court has personal jurisdiction over an out-of-state defendant as two-step inquiry. Of course, you want to check out this case, make sure it's good, make sure there's no issues, read it in full. But we get Simons, Fraley, Ferrand, Hunter. We have all those results, and we're still loading on this side. So we'll see what results we get here. And while this is loading, I'll let you know that this is a UI UX thing. For those that don't know UI UX, user interface, user experience, it's like the front end, the nice stuff that you see. And this is a technique used by most legal AI companies now, because in the old practice, you would just see like a loading bar or you'd see nothing. It would just be a spinner. But if you add in words and a loader that moves, it psychologically makes the user think it's moving faster. So that's actually a technique used by a lot of these companies. So we got a response here. It jumps right to citing the statute, cites a rule of civil procedure, a civil rule, and it's going through all these examples. Could be helpful, could not. But the interesting takeaway here is we did this search here. We did the exact same search here. And we found Simons, we found Fraley, we found Ferrand. I don't see any of those cases here. So you're going to get a literally different result using the same product from the same company based on whether you're going to use Gen AI search or traditional research methods. And I will say, this is still using AI. Like we talked about yesterday, there are algorithms that put this to the top. This is from September 2015, and obviously it's not the most recent. So there's some reason it's getting pushed to the top. I don't know what their algorithm is, but I assume it's based on relevance, how many times it's been cited, how authoritative it is, how many people read it or view it or save it. So there is some AI at play here, and then at play here is generative AI. But you notice you're going to get a different response. So that's something to look out for when you use this in practice, and this is still prone to hallucinations. So to go through, whenever you get a response here, what you could do is view all cited sources. So you could pop this open. You'll actually see the cases, see the citations, able to see the excerpts that are relevant, and then you could just pop it open and view it in Westlaw if you want to keep reading further. So it's helpful for that respect, but there's really no way to know for sure if this is the most accurate information. So my recommendation is you still have to do the traditional search. You could use this as a starting point, but given the fact that these cases are not even showing up in the top results of traditional search, raises a couple of questions about how useful it could be in practice, because you're still going to have to double verify using the traditional method. So I'll note one other thing, because this was annoying for me, so it might save you time. If you follow up and say, give me more, it'll actually force you to do a whole new search. So if you want to keep the conversation going, you have to click follow up. So now I could follow up, give me more, and it'll actually pick up the conversation. So it's not like ChatGPT where you just keep the convo going. You have to actively click follow up. And I didn't realize that for a while, so it's kind of annoying. Maybe I save you time. 2 questions. Yeah.
I forgot what the feature was called, but when you pulled up the actual cases and it had snippets on the side.
Yeah, you all cited sources.
Yes. Is that a way to find whether they're hallucinated cases or not, or do they also hallucinate on that end of things as well?
To my knowledge, they would not hallucinate here, because you could even verify. So you not only have the case site and a link, you then have the full citation, the excerpt, and you could just open it in Westlaw. So I mean, it's a good question, but ultimately you're going to have to read the case anyway. So it's good to click view cited source, open it up, and you're going to have to read that case regardless. So I don't know the answer to that, whether those still hallucinate, but what they're doing is they're grounding all their responses in authoritative case law. And this is one of the practices that legal AI companies are taking, where it's not like ChatGPT where it just gives you a random response. You're putting in an inquiry, and every time it gives you a citation, the system forces the model to ground its answer in an actual case that's in their data set. And you can see they link it and cite it all. So this is definitely going to be a lot more reliable. I don't know what the hallucination rates are at this point in time. The last big study was back in May 2024, but I would expect this to be a lot more improved.
Thank you.
Last cool feature I'll show you. Do we have another question or? Okay. One other feature I'll show you, you can actually click this download button and export this research into a Word document pretty quickly. So could be helpful. All right, so that's showing how the primary research works. We'll run an inquiry via secondary research now. So we'll go back, we'll open a new tab. We'll go to research, AI-assisted research. I'm going to put in the same exact inquiry. In Ohio, what is the rule for personal jurisdiction over an out-of-state defendant? Gives me the options. And I'm going to do search and summarize, practical law. And more on what's going on right now. So I mentioned how the answers are grounded in actual authoritative cases, which are then cited, and you could view all the cited sources. The technical term for this is a retrieval augmented generation. It's when you take a chatbot and have a conversation with a chatbot, but then when the chatbot gives you an answer, it could actually access an external knowledge database. In this case, the external knowledge database is Thomson Reuters set of cases. So it's literally going in, retrieving relevant information based on the keywords that you use in your inquiry, retrieving information, and then augmenting its auto-generated response to give you an answer based on the external database. So that's the big structural difference, retrieval augmented generation. That will be a question on the certification exam, so write that one down. But this is the response we get from the secondary source when we ask, what is the rule for personal jurisdiction over an out-of-state defendant? And you can see, pretty different. I'll say this is not very reliable when you ask questions about case research, and here's why. The very first thing cited is just like a standard document template. That's just on Westlaw. Not very authoritative. Can't cite this. Won't pass in the courts. So you can see it's helpful for secondary research, but only to an extent, because it's literally citing like templates and documents and not much authoritative case law at all here. So just be aware of that when you do your generative AI search using CoCounsel. Not the best, at least for this type of inquiry, where you're looking for case law when you use secondary sources. So we're going to shift back. We now covered research for primary sources, secondary sources. Now we're going to do search database to give you guys insight into how you could use this. Like I said, I pre-created a database pulling 3 cases on personal jurisdiction. So I'm going to pull up my pre-created database. You can make them super simply. You just drag and drop files after you go to the database section. So I have Penoyer, Worldwide Volkswagen, Bristol Myers Squibb, fan favorites, everyone loves them. So they're uploaded here. So now I'll say, give me an explanation of personal jurisdiction, citing all these cases for reference. And again, this is an example, retrieval augmented generation. You upload the documents. This is now an external knowledge database. The retriever component, all these LLMs, is going into your documents, pulling information relevant based on the keywords I used. Like explain personal jurisdiction, it's going to these documents, retrieving that info, augmenting that info when it gives the response to me. This might take a little while. Oh, no, it didn't. All right, so there's the response. You can see this one is also more reliable than ChatGPT. It's also going to ground its answers and cite them. So when I click this, it'll pop open on the side and actually show you the citation and even highlight it in the document I uploaded, which is not very helpful when you highlight the whole page. But anyway, you get the point. So it will ground its answer in the documents you upload, which is just increasing the reliability of it, but you're still going to want to verify. So like I said, one good use case, you have a memo, research, you already did all your great research, you have all these cases, drop them into a database here, and now you can interact with that database, talking just with the cases and documents you want to talk to help with your memo. We're now going to quickly we'll do summary quick. And I'll note, you may be thinking like, why do we need different sections for, let me go back, reviewing documents, summarizing documents, you're uploading documents, in both of them. This goes to like the system messages in the process. Remember the system messages? It'd be like, you are a lawyer doing this. So I would guess they have, in the background, different prompts and different processes. And again, few-shot prompting, one-shot prompting, that's also a technique used on the back end too. So what they're probably doing in the summarize section is giving it examples. Like, here's a document, and here's an ideal example of what a summary would look like. And then the system message would be, you're a lawyer tasked with summarizing a document. Here's the best practice for summarizing a document. And then it would do that. And they have a totally separate system message and prompt for the review section. So that's why it is likely broken up, even though they're two pretty similar things. So I'll quickly do summarize. I'll upload one of the documents we have from the database. And this gives you the ability to select single documents from your database so you don't have to speak with the whole database. So we'll do Penoyer. Explain the holding in this. Well, actually, we'll just do summarize this. And it's going to go through that document and then ultimately summarize it and give me that holding. All right, there we go. Also cites it all. So you pop it open again, see all the highlights. But that is how summarize feature works. So we've gone through research, we've gone through summary. We did not do a review because it's very similar. Upload a document, ask for certain key information or data points. Drafting, we won't go through just because of time limitations, but you could draft. Again, this will be good for a first draft, not going to be great for a final product. So that is a basic introduction to CoCounsel, and I will briefly go through some of the limitations and best prompting practices a little bit more in depth here. And we're going to run through them quickly due to time. One, these are all best prompting practices directly from CoCounsel itself. You saw that section where you get to choose between AI-assisted research or primary and secondary. There was that link that said about this source. Click on that, and it'll pop open this and tell you all the best practices. But we'll run through them briefly here. One, write clear, concise, focused queries, 1 to 2 sentences long. Don't do these run-on questions, run-on sentences. It will be very difficult for the LLM to ultimately give you a better response. So keep it clear and concise. It's recommended you reference the practice area, cause of action, type of law, and material facts, as well as your desired outcome. Do not write an inquiry in the style of a prompt, command, or instruction. They already did it on the back end, like we talked about with the system messages and pre-prompting. It's better to don't even include things like find me cases that. Just ask the inquiry, the legal inquiry. And I'll show you 2 examples, one bad, one good. Here's the bad one. You're an experienced attorney who's an expert legal researcher, and you need to find and summarize the best cases that discuss where the ADA requires an employer to reassign an employee to a vacant position as a reasonable accommodation. That is not a good prompt. On ChatGPT, it might be great, but here it's not because they pre-prompted and you're just adding extra words that could distract the LLM and give you a worse output. Here's the better inquiry, and these examples come right from CoCounsel itself in their best prompting practices. Does the ADA require an employee to reassign an employee to a vacant position as a reasonable accommodation? You get right to the point, you ask the legal question, no preface, nothing else. Focus on a single issue or question. Like we said at the start, clear, concise, 1 to 2 sentences is the goal, and avoid using proper names. And you probably know this from your research memos. When you write these rules, you're not including the names of people, you're not including their perhaps position if it's relevant, but you're excluding the names, similar to here. Not good to ask, is David Jones, as CEO, personally liable in a stockholder action against Acme? It's better to ask, can a company executive be held liable in a shareholder derivative suit? So remove the personal things, keep it more vague in terms of positions, not names specifically. Because again, by using David Jones, you might throw off the LLM and it might go find case law that has the name David Jones in it, rather than focus on the CEO aspects. PowerPoint issues again. Okay, and we're back. All right, some final ones. Finding documents by citations is a limitation. These are explicit limitations from CoCounsel. You cannot search cases based on citations yet, or at least accurately. You're not going to be using Boolean searches and fielded inquiries like using /P or /S. Those do not work in CoCounsel, the generative AI function. So you are looking at totally different practices from traditional research now using CoCounsel. Commands to execute certain tasks, summarize this, or email me this case. Those are things it cannot do if you're using the research function. You'd have to go to the summarize function if you want to summarize a case. Requests for comprehensive document retrievals. If you ask it saying find all cases all cases granting summary judgment on negligent misrepresentation claims, it's not able to do that. So you'd only ask targeted questions. You can't do comprehensive search yet. You cannot compare across jurisdictions yet. You can't say, how does each state do this, or compare this jurisdiction with that. Does not have the functionality to do that in co-counsel research. Requested summaries over time of how law has changed. You cannot do that yet. There are no ability to ask for general trends over different periods of time. Requests for standard or other rule set citation formatting, you can't tell it to put things in citation format. It will not give you an accurate response. So you still have the blue book. And there's just many of the errors that I ran into trying to do some different inquiries. So if you see these red boxes, no, you've probably ran into some of the limitations that we just talked about. Some of them are like, tell me about Penoyer versus Neff. Gave me an error and limitation there. So this is still a product it's live, but it still has limitations and issues. So if you run into them, just know you've probably run into one of those limitations we talked about, and just reframing the question or opening a new chat might help you get a better response. And one that I assigned you all was TRIGA. So TRIGA is this bill introduced in Texas last month. It's comprehensive AI regulatory bill. We'll be getting into it in the next session. But this is a very new bill, and why I had you research it was so that you did get an error to demonstrate that recent cases or introduced bills may not show up in your co-counsel search. Really important if you're doing legal research on a novel issue, or if you're doing some research for a student note. If you're using Gen AI, you might not be capturing the most recent cases. So you're going to want to go find those in traditional search, or perhaps directly at a court or something like that. So that rounds out the co-counsel demo. I'm briefly going to run through Lexis because we still have a good amount to cover on Spellbook as well as ethical considerations. So Protégé, this was launched, I think, like within the past 2 weeks. So this is very new. It's rather similar. So I'm now in Lexis, traditional search. You go to Protégé over here on the top right, or you go to Protégé over here on the top left. On the left, it'll pop it out as a full screen. So I get asked a legal question. In Ohio, what is the rule for personal jurisdiction? And before I do that, you can see here, you have the option to ask questions. This is the legal research function. You could draft stuff, you could summarize, and you could upload and chat with documents. Very similar functionality to co-counsel. And you'll see here, before putting in an inquiry, you're prompted to choose the jurisdiction, which again, now that we know, because of how large language models work, this helps narrow the potential responses you get. Because it's very difficult for these large language models to retrieve information across huge data sets of millions of cases. So by doing this, you're helping the model focus and you'll get a better response. So let's do all federal. I'm going to apply the jurisdiction. And now they actually have civil versus criminal content. This was recently added. This is another way that the model is able to refine and narrow the potential world of documents that it'll retrieve for you. So now that we've done those two, we'll click enter and we'll see what we get. Oh, interesting. So I selected all federal, but I asked in Ohio, what is the rule for personal jurisdiction? Technically, my question does not eliminate the fact that Ohio is still in a federal jurisdiction. So that was an interesting outcome. Did not expect that. But let's say, what is the rule for personal jurisdiction over out-of-state defendants generally? So Protégé is interesting. They introduce this step-by-step, so it'll actually show you the thinking process. I do expect co-counsel to introduce something similar. It just feels more authoritative, and user experience is pretty huge on a lot of these platforms. So it's going through analyzing the prompt, consulting, examining. I'll also say some early stage startups also add these steps in as total nonsense. They don't actually go through those steps, but it just looks good optically for a user. But here we do. We have a response. And all right, this is interesting. So I just changed my inquiry to what is the rule for personal jurisdiction over out-of-state defendants, and it actually jumped back to Ohio state law after I just asked for general. But you go to see that these are still very experimental, not yet there to replace legal research. And it's even an open question whether this is more efficient than just doing traditional legal research. Because we saw how quickly cases came up. We saw that usually the most cited cases or most read will go to the top in traditional research, and this is more experimental. So it's an open question. I'm not a huge advocate for generative AI research yet. I do think it's important to know, to use, to understand the limitations, and I do think it will get a lot better over time. So that rounds out the 2 legal research, and we're going to jump right into Spellbook to show you how AI tools are being used in the transactional context. So I'm pulling up a software as a service agreement, and it's 41 pages long. And what I have here is I have Spellbook. It's this plugin that allows you to analyze contracts using generative AI. So I'll pop this open, and now I could chat directly with Spellbook. Let me try to expand this. Okay. So I'm going to say I am representing Anthem. Are there any terms adverse to my client? It's just like talking to ChatGPT, but again, fine-tune, so it has this data set of hundreds of thousands of contracts, so it knows more about contract law, and it's reading my document and incorporating the document into the answers. So you can see some of the things that are bad for my client: termination upon competitor change, limitation on liability, indemnification, no exclusive rights, force majeure. So you can see this is an immediate value add. This is a 41 pages contract, and immediately I already know what terms should I go investigate further because they're adverse to my client. And you could also do certain sections. So I just want to do a section. You could actually ask questions just based on a section. You could go to drafting and draft new clauses. Draft me a non-compete binding Castlight's CEO. And it'll go through using all those hundreds of thousands of documents of ideal contract language. It's able to draft any provision you could really think of. So that's what's going on here. And just like that, it gives you language and actually incorporates the names automatically. You don't even have to plug them in. So here we go, termination, or there we go. Termination or expiration of this agreement, the CEO of Castlight is bound, and you can actually toggle to look for other non-competes if you don't like that iteration. And the final cool feature I'll show you is review. You could review the document in full, and it'll identify obvious risks, do a whole report of what the weaknesses are, and you also have benchmark. So this literally tells you, compared to standard SaaS agreements, software as a service agreements, how does your document line up? And this is a very bad document. 47% coverage. We're missing things about data protection, amendments for regulatory change. So we're missing a lot of stuff here. And this is able to tell you what's missing and help you improve your contracts. So you can see this has been around a long time. Contracts are more standardized, more formal. A SaaS agreement, generally there's an understanding of what provisions there will be. There's some level of negotiation, but given that more stable aspect, more formulaic approach, this is a lot more reliable way to use generative AI in contract review. So this is one way that generative AI is transforming contract review in practice, and this is something that's widely used among law firms. So we are now down to 13 minutes, and we're going to jump into everyone's favorite part, ethics. So professional and ethical obligations for legal professionals using generative AI. Starting off, all existing ethical and professional obligations apply to the use of AI. There's this trend among these AI-related bar ethics opinions where basically what they do is they analyze existing ethical rules and rules of professional responsibility, and they just say, these rules apply to the use of AI tools. Nothing's new. You're still obligated to communicate with your client, double check your work, not overcharge fees. So there's not actually any new rules that are AI specific. There are opinions opining on it and applying existing rules, but just know nothing's really changed in terms of your obligations as a lawyer. When you're using these tools, you need to know how to use them, you need to communicate with your client, and you need to use them responsibly. The first bar ethics opinion to come out was out of Florida in January of last year, and it was advisory, it was non-binding. I'm not going to go in depth on it because it's actually been interpreted in an article by an Ohio lawyer that the Ohio bar has technically blessed by posting it on its site. And I'll get into more detail about what I mean there. In 2024, July of this past year, the American Bar Association, which is the largest voluntary bar association of attorneys worldwide, based in the US as well, it issued its formal opinion 512. This is basically just general guidance to lawyers about what to consider, what rules to consider, and ethical obligations when using generative AI in practice. This was also advisory and non-binding. And the ABA does not bind the states, so it's up to the states to adopt their own ethical opinions, as well as their own rules of professional responsibility. Since the issuance of this ABA opinion, as well as the Florida opinion, other states have issued their own opinions and guidance on AI. They're all very similar. So when we cover the ABA one, you'll have a general understanding of how other states are approaching it as well. Other states include California, Michigan, Pennsylvania, Kentucky, North Carolina, and others. And Ohio, not quite. So Ohio does not actually have a formal ethics opinion on AI, but what they did do last year, they posted an article by an attorney who's unaffiliated with the bar, and it's just her opinion on what rules in Ohio apply to the use of generative AI. And she essentially cited the Florida opinion and went through what rules she thinks applies. The Ohio State Bar has not issued anything else since then, so it's literally just this attorney's article on the website, and that's the extent of AI ethics guidance in Ohio. And we're going to run through it. These largely mirror all of the guidance and thoughts and opinions from that Florida opinion, and the ABA opinion largely tracks the Florida opinion too. So all these opinions are generally covering the same things, just in different jurisdictions. So first, in this article, which I link on the next slide here, so feel free to read this. It's called Adopting Emerging Technology Responsibly by Marissa Bowers, February 14th of last year. So here's what she said. She said that client names and sensitive information should never be entered into publicly available generative AI tools. That's according to Ohio Rule of Professional Conduct 1.6. Number 2, if an attorney discovers AI-generated errors, you have to alert the court. This is the duty of candor to the court. The citations to the civil rules, as well as the rules of professional conduct, are cited right there. Billable hours should not be inflated to offset AI efficiencies. Essentially, if I were to review that 41-page contract and identify all the potential adverse elements for my client, it would take maybe 2 hours or write up a memo, but then I just used Spellbook, took me 2 minutes. I can't use that Spellbook tool, spend 2 minutes, and charge for 2 hours. So the offset efficiency gains, you cannot charge for those. It's only the time you're actually using the tools in practice. Number 4, attorneys in supervisory roles, they have to be responsible and take reasonable steps to ensure that the people under them, being associates, paralegals, legal analyst staff, that they're well trained in using AI and basically know what they're doing. Because if someone under your supervision files a hallucinated case or takes some action that's unethical, it's on you as a supervising attorney. So you can see here, these are just the author's opinions posted on the bar's website, Ohio, so it has some level of credence to it, but it's not an official ethics opinion in Ohio. This is just guidance. And again, like I said, notice there's no new rules coming into effect on AI specific. It's looking at all these existing rules. Every one of these cited rules is an existing bar rule or professional ethics rule, and it's just applying these rules to the context of generative AI tools. So now we're going to shift to the ethical obligations of lawyers when using AI through the lens of this ABA Opinion 512 from July 2024. This is one of the more authoritative and well-cited opinions when people talk about ethical obligations when using AI in legal practice. So the main takeaways from this opinion are lawyer competence, confidentiality of client data, communication with your client that you're using generative AI, and charging reasonable fees. Very similar to the Ohio points we just ran through. But you'll see first, this ABA opinion restated the fact that all lawyers have a duty of competence. If you're going to practice law, you need to be competent in what you're doing, and that entails being competent in the use of technology that you're using. So this model rule 1.1 from the ABA on competence already exists, and the opinion just said this rule is extended to generative AI tools. You need to know what you're doing and be competent before you use these tools. Model Rule 1.6 from in the ABA, which has been widely adopted by many state bars, is about confidentiality of information. You have a duty, pre-AI, post-AI, during AI, to always to store client information that is confidential. So it's your obligation as a lawyer, no matter what the context, to keep that information secure, cannot disclose it publicly. So this rule simply extended to AI and covers AI to say you can't be putting your client's information that's confidential into a chatbot that can regurgitate it to someone else. So it's just extending this rule, clarifying that it does cover AI contexts and chatbots. The ABA rule, the ABA formal opinion, also talked about Model Rule 1.4 on communications. That is, you always have had a duty as a lawyer to communicate important things to your clients regarding decisions or actions that you're taking. And using generative AI tools, that's an important decision. So that's something you have to talk to your client about, and it's covered by this existing rule of your duty to communicate with your client. And Model Rule 1.5, reasonable fees, I just gave the example, but this ABA opinion also reemphasized that you can't be charging a bunch of money for something that you didn't do because you use an AI tool to expedite that process. There are some caveats. You could actually talk to your client beforehand, explain what you're going to be doing, what you're going to charge for. You could charge flat fees as an alternative. So there are other ways around it, but generally you cannot charge for the efficiency gains that you get from AI. So those are the general rules. When this ABA opinion came out, said we already have these existing rules, all of them apply to AI, and it gave some examples. So I'm going to emphasize some other things to close out our last 5 minutes. One, there's a strong emphasis in this ABA opinion, similar to that Ohio article, where it emphasized that lawyers have a responsibility to manage and supervise people using AI. So if you ever find yourself in a position managing others, it's your responsibility to ensure that they understand how to use them and be able to monitor what they're doing with their AI. And it's important to establish clear policies. That was a strong emphasis. There's still many law firms that use AI tools but have no clear policies. So that is definitely problematic and something that I expect more law firms to shift to, having these clear policies to cover themselves. Some other interesting aspects, self-learning generative AI tools may disclose information. This is a quote directly from the opinion. And because they may disclose information to the public, you need your client's informed consent prior to inputting information relating to the representation. So if you're putting client confidential information, their name, details of their case, into a generative AI tool, according to the ABA opinion, you must notify your client. So in theory, you're using relativity, uploading sensitive documents, you need your client's consent. If you're going to use ChatGPT and put in client-sensitive information, which you should not be doing in any case, you technically have to talk to your client about that, get their informed consent. And what is informed consent? It's not simply, hey, I'm going to use ChatGPT, and you say in a meeting. You need to fully outline why you're using it, what the risks are, what the benefits, likely outcomes, potential possibility that their information could get regurgitated out to someone else. So you need to fully inform your client about your use of generative AI tools. This has been pretty widely criticized by people out in the legal community on this, because to get permission every time you use a generative AI tool could be a lot. So this is an ongoing debate about what levels of informed consent you really need to do for even small use cases. With this all said, they've even said in the ABA opinion, boilerplate language in a contract is not even sufficient. So you can't even put in your agreement with a client, your onboarding letter, like, oh, we're going to use generative AI tools. You actually have to inform them proactively about all these risks, and a one-off sentence in an agreement, an engagement letter, will not be sufficient. With that said, idea generation, totally fine. This is one of the things where you do not need to inform your client. If you're a lawyer just using AI to ideate ideas in ChatGPT, you don't have to tell your client because you're not using it and putting their sensitive information into it. I'll add a caveat. The ABA opinion does say if you're making consequential decisions based on generative AI tools, you have to inform your client. So if you're using it to generate ideas, to then act on those ideas in a high stakes, maybe jury selection, then you have to tell your client. So it's kind of up in the air. There are some rules on when to inform your client, some obvious ones when you're putting in their data, but there's kind of a debate in some gray areas that are still playing out in this space. So other AI-related obligations, last 2 minutes, so I'll close out because you guys all read this for today. Illinois Supreme Court came out with an ethics, really less ethics, more so just guidance on the use of AI It was effective starting just last month. And they're all in on embracing AI. They say it's going to be very beneficial, but at the same time, they do recognize that it could be problematic in hallucinations, exacerbating discrimination and bias. But they said that you could use AI, we should not be discouraging it, we should be encouraging it, but misuse is not tolerated. They basically just reemphasize as a lawyer, when you sign pleadings and file them in court, you are responsible for those cases, whether it's messed up due to AI or non-AI. So they're not going to discourage it. It's just reemphasizing we have obligations. And the reason I included this is because this is the new trend. Like we talked about yesterday, Judge Brantley Starr, Northern District of Texas, came out almost 2 years ago now with this guidance saying you have to certify if you use AI or not. But now we're moving away from that because it's really just a double requirement. You already have to certify that everything you file with the court's accurate. And this is an example of that trend in that direction. One other example as we close out, the Fifth Circuit, they entertained the idea of implementing an AI certification requirement. Lawyers pushed back, and they ultimately said, no, we're not going to do an AI-specific certification, because they again said, lawyers are responsible for their filings. I used AI will not be an excuse for otherwise sanctionable offenses. So no appellate court has come out with a directive or standing order on certifying AI use or non-AI use, and it doesn't look like there will be anytime soon because it's just viewed as a double requirement at this point in time. But that rounds it out. We now have an hour break and one more session left.